So now we're up to chapter 3, which is dealing with land use controls and regulations. And, I guess for the most part, what we're going to be dealing with in this chapter is, if you own land, do you really own it? Could anybody else have any control over your land? And I think you're going to find by the time we finish this chapter, if you didn't already know this, the answer is absolutely yes. And probably one of the primary entities that will have significant control over your property is the government and what their rights are. But we're going to take a look at some of these things and see if we can figure it out. Now, you'll notice in this chapter, there's just 4 questions that you're going to get on the national portion, but we're going to talk about what these government rights are. And we're going to be talking about something called police power. That's always fun. And some environmental hazards we got to be aware of, and some both public and private controls that we're going to have to comply with, again, as landowners or property owners. So let's get started. First thing we're going to look at are what are some of these government rights in land. And obviously the biggie is their right, the state's right to tax the property. So yeah, if you own property, you will have to pay property taxes, and those taxes are due every single year, every year. And you can say you own that land, but try not paying those taxes and see how long you own it. So look, we got to pay the taxes. Probably nobody really enjoys paying them that much. I know I don't. It seems like it's always a little bit more every single year. Taxes go up. But we need to kind of understand how these taxes work. How do they determine how much your taxes will be? Well, you see some terms here on the slide. Obviously, everything you see on the slide will be in your book as well. But there's some terms there you kind of need to be familiar with to kind of understand how property taxes are determined. But the first thing you see here is something called point of sale. And really what the point of sale means is now taxes are based on whatever you paid for the property. So say you buy a house today and you paid $200,000 for it. Then the county says that's what it's worth. It's called point of sale. Now we'll tell you, prior to point of sale going into place or becoming law, the appraised value for tax purposes was always much less, quite frankly, than what you could expect to actually sell the house for. And that was a good thing, because obviously the lower they had your house assessed at, the lower the taxes would be, because the more the value, the more taxes. But then they decided to change the law, what we now know as point of sale, which now really just says, whatever you paid for the property, that's what your appraised value or the market value would be, at least for tax purposes. Now, I will tell you, the assessor does have the right, and they do this, if they feel like you just got an incredibly good deal. Maybe it wasn't really an arm's length transaction. Maybe you bought it from a family member that was just really cutting you a really good deal. You got it for half price or something like that. The assessor's not going to let that fly. Then the assessor's going to go say, no, I know you only paid $100,000, but it's actually worth $200,000. So they can just arbitrarily change that appraised value to whatever they believe the value to be. But assuming it's just an arm's length transaction and both parties were trying to get the best deal for themselves, then that is considered the point of sale. Y'all, that now establishes what the appraised value is for tax purposes. So, y'all, that's what point of sale is talking about. But then you see the term ad valorem. Y'all, obviously the state has the right to tax property, both real property and personal property, right? Y'all, they can tax your car, you got boat, motorcycle, y'all, you name it. So it's not just land and houses and stuff like that. Y'all, they can tax anything, and do. But the law does say if the state's going to charge a property tax, then it must be an ad valorem tax, meaning the taxes you pay will be based on the value of the property. So the more value, the more taxes. That's what ad valorem means. You know, it really wouldn't be fair to say every single homeowner has to pay the exact same taxes, because my neighbor's house might be worth $500,000 and mine's only worth $200,000. Why should I have to pay the same amount of taxes that he's paying, right? So it's based on value. And then you see the term millage, and you're going to see all this coming together in a minute, how we actually calculate these taxes. But then the term millage basically is just more taxes, is really what it is. Because see, what the county will do, each county, they'll have like a budget, if you will. So they have to figure out how much money will we have to generate, obviously, in taxes to pay for everything that needs to be paid for in the county. You can start naming stuff off. There could be a list of things, but obviously, just for an example, one major expense in every district is going to be the schools, the public schools. They have to be paid for. So they'll take a look, given the number of property owners in that district, they will determine how many mills they'll have to assess each property owner to generate enough taxes to pay for our schools, right? So, and it's not just schools, but, if they got road maintenance, we got to pay for that. We got district or state or county employees, we got to pay them. So they'll assess a certain amount of millage towards each property owner to ensure we have enough revenue to pay for all these things. And that's really what they're talking about there. And then you see these general and special assessments. We kind of talked about that in the previous chapter a little bit, certainly these special assessments. But all that is really, it says it's additional taxes on properties that's benefiting from a betterment for something the district has done. An example of what they're talking about, let's say you live on a street where they've decided to put a sidewalk in. Or maybe there was a sidewalk, but it's in such bad condition, they just decided to replace the sidewalk. But at any rate, so they're putting in a new sidewalk. Well, who's going to pay for that sidewalk all the way down the street? Well, whoever is benefiting from that sidewalk. So if you own property, obviously that borders that sidewalk, then whether you think it so or not, the county believes you are benefiting by that. So guess what? You will help pay for it. And the county will issue a special assessment or potentially a general assessment. I won't get into the difference. It's not that big a deal for test purposes. But they will issue the assessment for however much money for whatever your prorated share of that sidewalk would be. So really the whole district or county's not paying for it, not for that assessment. It's just whoever is benefiting from whatever's being provided. Those that benefit will have to help pay for it. That's what the assessment is. And again, you'll see that assessment show up on your tax bill at the end of the year. All right. Now in South Carolina, and again, this is just South Carolina. Other states, I'm sure, do things differently, or at least a little bit differently. But, there are several quite a few different assessment rates in South Carolina, and we need to talk about that. Because y'all, these assessment rates they determine how much your taxes are going to be. The good news is, even though there's several different rates, and obviously depending on the type of property and how you're using the property will kind of determine how much the rate will be that you're having to pay in taxes. There's several of them, but there's only two that you and I need to be really familiar with or care about, certainly for test purposes. And you see them listed here. But one is the 4% rate, and then the other is 6%. Those that own a house and live in the house, they pay a 4% rate on that property. But again, you must own it and live in it to get the 4% rate. Y'all, you can only own one property and be able to pay the 4% rate, y'all, which is the cheapest rate, okay? If you own any other property, investment properties, vacation home, y'all, whatever, then those properties will be taxed at the 6% rate. Now, y'all, just to be clear, and y'all, they could ask you something along these lines on the exam, so I just want to make sure we cover it here, which I already said it, but I want to be very clear. Y'all, let's say I own a house, obviously, that I live in here in Columbia, South Carolina. But I also own a beach house on the coast. Now, typically, if you had the choice, which one of those houses would you prefer the lower rate? Obviously the one on the beach, because it tends to have, it's more valuable just because it's on the beach. It's going to cost more. So I would rather have the 4% rate on the house at the beach, and then I'll just pay the 6% rate here, because again, I can only do the 4% on one property. Y'all, that's a no-no. You can't do that. Y'all, the law says the property that you claim at the 4% rate, again, you must own it, but you also must live there. Now, some might try to make the argument, well, but what if I kind of split the difference and several months out the year I live on the beach, I stay on the beach, and then several months I'll stay in Columbia. Okay, well, if it's that close a time, then the law says then whichever house you live in most of the time. So if you got to start counting down months, days, or even hours, but you better be able to prove that whichever one you're claiming the 4% rate on, it better be the place where you live most of the time. Then you get the 4% rate for that property, but everything else will be taxed at 6%. Now, just looking at those percentages, it really doesn't seem like there'd be a whole lot of difference between, say, 4% and 6%. But I'll just tell you, because of other things that go into this that we're not going to get into in this course, it's not necessary, so I'm not going to go there. But I will tell you, there's a lot more that goes into that 6% that makes it very expensive. In fact, I'll just tell you, for those that don't already know this, y'all, the difference between 4% and 6% on average is about 3 times. So for example, if you're paying just to make numbers even, say you're paying $1,000 a month, a year, $1,000 a year in taxes at the 4% rate. Y'all, if that same property was being taxed at the 6% rate, you're looking at somewhere around $3,000 to $3,500 a year for the same property. So y'all, that's a huge difference in how much taxes you're paying between the 4% rate and the 6% rate. So it's a big deal. It's a huge deal. So how are these taxes calculated? How do they determine the taxes? You will have to be able to do this on the exam. Well, you see on the bottom of the slide here, and again, it's in your book, but there's a formula. You also tax formula, and it's a two-step formula. If you'll remember this formula, you should have no problems answering any kind of tax question they ask. And they will ask you one or two or more on the exam. I promise you that. But let's look at the formula. The first step, it says you take the appraised value times the assessment rate. That will give you the assessed value. And then the next step is then you take the assessed value times the millage rate, and that will be whatever your property taxes would be. Obviously the theory, not just theory, but the fact of the matter is, if I know any two of those three components, shouldn't I be able to figure out the third? Obviously if you know the appraised value and you know the assessment rate, you just multiply those two and that will give you the assessed value. And then you plug the assessed value down on the bottom line, where now you just take that assessed value times whatever the millage rate is to get your taxes. So, obviously they'll give you enough information in the question to be able to fill in enough of these blanks to be able to figure out whatever it is they're asking you for. Okay? Let's just look at a practice question here. Now this is not necessarily, in fact, it's not in your book right there. But this is just something we're going to just practice with, see how this works. But here's the question. It says the rental property has been appraised at $92,500. If the millage is 127 mills, what are the property taxes? Okay, well, first of all, let me say something about the mills here, okay? They will give you, like in this question here, it's 127 mills. So you have to convert the mills into a millage rate. All right? Very easy. All you have to do in this case is just stick a decimal in front of it and make it 0.127. So 0.127 would be the millage rate. Now I will tell you, because it's mills. What you're doing here, you're having to move your decimal 3 places. So if you move it 3 places, that would be in front of the 1 to make it 0.127. But say the mills was 1127, so 1,127. What would the millage rate be? Well, if you move it 3 places, that'd be 1.127. So again, if they just provide the mills, then you got to convert that to a rate. And by doing that, all you're doing is moving the decimal 3 places. Okay? For some reason, the mills would say just 27. Then you would have to add a 0 on the front of it, and it'd be 0.027. Okay? So you move the decimal 3 places. That's it. All right, so now that I've been running my mouth here, if you haven't already figured out the answer to this question, go ahead and work that out real quick. I'm going to pause from talking, and using the tax formula I just gave you, let's see what we come up with. All right, hopefully that was enough time. I know I didn't give you a lot of time there, but so what did you come up with, and did you get the right answer? Well, let's take a look. So again, if we have the formula, and y'all, I went ahead and rewrote the formula out there and then plugged in the numbers. We know the appraised value was $92,500, but you notice it says a rental property. Now, what did we just say earlier? What's the assessment rate for a rental property? Is it 4 or is it 6? Well, the 4% is a owner-occupied property. If this is a rental property, it's not owner-occupied. So obviously we know the assessment rate is 6%. Y'all pay attention to stuff like that. I'm telling you, if you just plug in the wrong rate, because they didn't tell you 4 or 6, they just told you the type of property. And then you're supposed to know what rate would be assessed there. So if it's rental, it's 6%. So $92,500 times 6%. So now we know the assessed value is $55.50. That's the assessed value. Now I drop that down to the second part. The $55.50 times the millage rate, because now you notice you can't just put the 127. Y'all, it's got to be a rate, got to be a decimal there. So $55.50 times 0.127, and you should have come up with the taxes of $704.85 a year, at least on that property. Right? Y'all, and you'll get some more practice questions very similar to this towards at the end of the chapter. You'll see some more, so you'll get some more practice here. But y'all, you got to memorize this formula. Y'all, I'm telling you, you're going to have problems if you don't memorize this formula here. They're not going to provide the formula to you in the question, but y'all, if you can remember it, you'll have no problems answering these type of questions. Okay? All right, moving on. The next right the government has is something called rollback taxes. Now, y'all, obviously this is also important for test purposes, but y'all, this is critically important to understand this when you're out there practicing real estate. Y'all, otherwise, y'all, you could cause people to actually lose their property because you weren't giving them good advice. Y'all, this is something you better be careful with right here. All right. So, but here's what this is talking about. What a lot of people will do is, well, first of all, going back to that assessment rate, remember we talked about 4% and 6%? 4% owner occupied, 6% for everything else. Well, the law does say you can pay the 4% if it's owner occupied property, but y'all, it's only for up to 5 acres of land. If you own more than 5 acres, even where you're living, if it's on more than 5 acres, the first 5 acres will be assessed at the 4% rate. But y'all, anything over 5 acres is going to be assessed at the 6% rate. So y'all, those that owned a lot of acreage, y'all, the taxes can just eat you alive. Y'all, especially when you're paying the 6% rate and you own a lot of land. Y'all, I'm telling you, it's crazy. So what the county will allow is, you could have the property, let's say you own 20 acres or somebody owned 20 acres of land and obviously their house is sitting on it. They got a house sitting on 20 acres. All right, so they could classify all that land as agricultural property. Now, that's something you physically have to do. You can't just say it's you got to file this with the assessor and let the assessor know that you're now claiming this property to be agricultural property. The entire 20 acres is now agricultural property. Well, once it's classified agricultural, the county does not consider agriculture to be the highest and best use of the property. So therefore, they're not going to tax you at the highest and best use. So in other words, as long as it is agricultural, they will allow you to pay the 4% rate on the entire piece because it's now all considered agricultural. But here's the catch. It has to be used for agricultural purposes. You can't just say it's agriculture and then not use it as agriculture. It's got to be used that way. So agriculture can be really used or defined in really 2 ways. Obviously you could be growing produce of some sort, corn, beans, cotton, whatever. Or, what probably most people will do to claim agriculture is to have timber on the property. And if there's not timber already on it, they'll just go out there and plant little pine seedlings all over the place. But it says here that if what you're claiming as agriculture is timber, trees. And by the way, you can't just have 3 or 4 trees scattered out on this 20 acres and say that's my, no, the entire property must be planted with trees, okay? You can buy these little pine seedlings, for example, for a couple pennies a piece. They're not much, but you go out there and plant them, and then you can now classify it as agriculture. But if what you're growing is timber, trees, then you must have a minimum of 5 acres of timber. Otherwise, they will not allow you to classify it as agriculture. But 5 acres or more, you can classify as agriculture. But any other products you're growing, hopefully legal products, all right, corn, cotton, peanuts, whatever, then you have to have at least 10 acres of anything that's not timber, okay? So there is some requirements to be met here to be classified as agricultural. And it has to stay, and it has to continually be used for agricultural purposes. Now here's where you better be careful. Anytime you're working with someone buying or selling property that contains more than 5 acres of land, if it's more than 5 acres, this is where you better pay attention, and you better not forget this. Let's say I've got a buyer looking to buy this property and there's 15 acres or anything over 5. But what I'm interested in knowing is, what is that property classified as? Because good chance, if it's more than 5 acres, they've gone in and had it classified as agricultural property. Okay? Again, to get much cheaper taxes, trying to get that tax bill down. Once it's classified agricultural, if you ever change the use, in other words, if you ever do anything with that land other than agriculture, now you're going to be liable and will have to pay rollback taxes. Now I'm telling you, this will rock your boat, whoever has to pay these rollback taxes. Because what they're going to do, they be in the county, once you change the use or use it for any other purpose other than agriculture, at that point, whoever owns that property at that point will now have to pay the rollback taxes. They're going to go back a period of 5 years and then determine what was the difference, or what would have been the difference in taxes between the 4% rate and the 6% rate over the last 5 years. I'm telling you, that's going to be a lot of money. So you're paying 5 years worth of taxes, but not at the 4% rate, but at the 6% rate. I'm telling you, that's going to be a huge tax bill. And if you're not able to pay those taxes when they send it to you, they're going to take the property from you. So this is why I was saying a few minutes ago, if you're working with somebody buying and or selling property that's more than 5 acres, you better look into seeing, is it classified as agricultural? Because if it is, and they try to do something else with that property, somebody's going to have to pay these rollback taxes. And the person that changed the use will be the one that has to pay it. And look, and here's where I hear people arguing and whining and crying all the time, and sorry if you don't like it, but it is what it is. But let's say I bought the property I bought this 15 acres of land. What I did not know, or maybe I did know, it really doesn't matter whether you knew it or not, but y'all, the seller, before they sold it to me, had already classified it as agricultural. But then I buy it, I move in, and then one of my children, which is away from college, has now just graduated and coming home. And I say, no, you're not coming back with me and mama. We're kind of used to this empty nest thing, and you can't stay here. But what I might do is say, I've got 15 acres here. I'll give you a piece of land, and you can build a house on it or whatever. Wait a minute. Now, if you build a house on anywhere on that 15 acres, have you now changed the use of that land? Yes, you have. And guess what? You're now liable for rollback taxes. Okay, but I've only owned this property for less than a year. You telling me I now have to pay rollback taxes for the last 5 years? Yep, that's exactly what's going to happen. Y'all, it doesn't matter how long you've been there. You owe 5 years worth of rollback taxes. And I'm telling you, if somebody did, especially not knowing or understanding what they've done, and all of a sudden they get this tax bill for $50,000, $75,000. I'm just making up a number. And then obviously they can't pay it. They don't have the money to pay it because, one, they didn't know about it. Y'all, guess what happens when you don't pay your taxes? The county's going to take the property from you. Y'all, can you see where if that was your client that bought that property and they were not informed about this agricultural classification, do you think they're going to have a problem with you down the road? I can assure you they will. Frankie, why didn't you tell me about these rollback taxes? Why didn't you tell me that it was classified agricultural before I bought it? Why didn't you tell me all this stuff? Y'all, and you're going to have a problem if you're their agent. You're providing this legal representation and you did a pretty poor job. Y'all, you could have some problems down the road here. So, y'all, be careful with these rollback taxes. So, y'all, they are obviously critically important when you're practicing real estate. But obviously, you better understand the things we just went over for test purposes as well. All right, moving on from there. Y'all, another example of the government's right would be this thing called eminent domain. Y'all, eminent domain, in a nutshell, is the right the government has to take private property. Y'all, they can take your property for public use. So if the government feels like we need to take your property to benefit the public, they're going to take it. Y'all, and that's called eminent domain. Now, you don't have to like it, and you certainly don't have to agree with it, but they're going to take it whether you like it or not. Now, for the government or the state to be able to take private property through eminent domain, y'all, 2 conditions must be met, and you need to remember both of these for test purposes. The first reason they're taking it is, y'all, it's got to benefit the public, okay? Y'all, technically, legally, even though, y'all, we're seeing in certainly some northern states that are actually starting to do this right now, which is beyond me. I don't know how they're getting away with it, but they're doing it. But y'all, legally, it has to be for public benefit. In other words, y'all, could the state come in and take property you own and just give it to somebody else? No, that's not for public benefit. They're trying to benefit somebody, but that's not for the good of the public. But if they're taking, y'all, say they're having to widen a road, and that's going to require taking some portion or maybe even a large portion of your yard or property that you own, then they can do that because they're saying, because, for the good of the public, we got to widen this road. So we're not taking it, giving it to somebody else. We're taking it so we can have more road here to accommodate all this congestion and traffic. That's what eminent domain is for. So the first condition that must be met, it's got to be for public benefit. And the second condition says just compensation must be paid. So they do have to pay you whatever the property they're taking is worth. Now, I don't know if any of you or how many of you have ever experienced this or know somebody that has had to go through this, losing property through eminent domain. But one thing I would recommend, I wouldn't just assume that what the state is offering me is actually what the property is worth. I would actually, if it were me, I would hire an appraiser to appraise the property that's being taken. Because there's more to take into account here than just what they're taking. The value of what they're taking is one thing, which is probably all the state might be looking at. John, I'm just making up a number here. They might be saying the value of what we're taking is $10,000. That little strip to widen the road will give you $10,000 for that little strip. Well, there's more to it than that. Because when you take that strip or that piece of property from me, how does that affect what I've got left? Could that actually depreciate what I've got left? And maybe, what you took was worth $10,000, but when you take it, that's going to depreciate what I've got left by $20,000. So as far as I'm concerned, that's $30,000 that you owe me, not 10, right? But you're going to have to be able to prove to the state what the value of that property is by them taking it. And to do so, you're probably going to need to get it appraised. So if it were me, I would want to get the property appraised. So the appraiser's looking at what the depreciation is for what's left, plus what the value is of what they're taking. That would just be a recommendation. But that's what eminent domain is. Now, you see another term there called condemnation. Condemnation, that's just the legal procedure that the state uses to take private property for public use. Be familiar with that term condemnation, because I'm telling you, a lot of times on the state exam, rather than, they might be asking you a question about eminent domain, but they won't use the term eminent domain. They may just use the term condemnation. It's the same thing. So don't let that confuse you. Condemnation, eminent domain is the same thing. It means the state's taking private property for public use. That's what they're talking about there. And then make sure you remember the two conditions the state must meet to do this. The next right you see for the government is the term called escheat. Escheat, it says, is the reversion of property to the state when one dies intestate with no legal heirs. Well, first of all, what does intestate mean? If you died intestate, that means you died without a will. Testate means you died with a will. Intestate, without a will. So what they're saying here, if you die and you have no will to indicate who's going to get the property, and the state cannot find or is not aware of any legal heirs, then what do we do with the property? Obviously, it will go to the state. The state will take control or ownership of any property you left behind without a will or any legal heirs. Okay, now if there are legal heirs, then the heirs will get it. Now, how that's divided up, obviously it'd be up to the state to do whatever they want to. Just real quick, if you're 18 years of age or older, and if you're taking this course, then I assume you're at least 18 or fixing to be, then you need a will. y'all don't take the chance of dying without a will. Y'all, that's going to leave your heirs, loved ones, in a really bad place if you die and there's no will. Y'all, I won't get into all of it, but I'm just telling you. And if you're a parent and you have adult children, 18 or older, I'm telling you, you're going to save yourself some grief if y'all make them have a will. You say, well, but they don't own anything. Well, y'all, that's not all a will does. Okay? Y'all, if nothing else, you need to have a will to appoint someone as your personal representative. Y'all, someone to handle your affairs when you're gone. Because if there's no will and no one's been appointed by that person to handle their affairs, then guess who's going to handle it? The state. And I will tell you, I don't think I remember the last time the state made a decision that I agreed with. So I certainly don't want them making decisions on my behalf when I'm gone. So, y'all, make sure you got a will. Get a will. All right. Now we get into this term called police power. It says police power is authority granted by the state. Could be granted to a person. It could be granted to an office. It could be granted to an association, whatever. But they've been granted this authority to enforce certain rules or laws, regulations, whatever it is they've been put in charge of. Because they have this police power, that means they can take any action they deem necessary to enforce whatever rules or laws they've been put in charge of. Okay? That's what police power means. It's just authority granted by the state. That means you now have the authority to take any action you deem necessary to enforce whatever it is you've been put in charge of. Now, there's several examples of this police power we're going to take a look at. And the first example would be restrictive powers. Just for example, the one we use here, when you get your real estate license, do you have or will you have to comply with real estate license laws when you're practicing real estate? Obviously, the answer is yes. Well, if you had to guess, who do you think has police power to enforce the license laws? Y'all, that would be the Real Estate Commission. Y'all, it's part of LLR. Y'all, the Real Estate Commission falls under LLR. Y'all, LLR stands for Labor License and Regulations. Y'all, it's kind of like a great big umbrella. And you got several offices within LLR, one of those being the Real Estate Commission. You got the Appraisal Board and the Auctioneers Board, the Builders, Contract. Y'all, they're all underneath that LLR umbrella. But each one of those entities, in this case the Real Estate Commission, has been granted police power to enforce the real estate license laws. Means they can take any action necessary to enforce them. So y'all, if you break the law, or you're not complying with the requirements to practice real estate, can the Real Estate Commission take your license away from you? Yes, because they have the police power. Could they fine you? Yes. Again, because of the police power. They can do stuff like that. Another example of police power would be zoning laws. Obviously, that's a big deal in real estate. But in a nutshell, all land, every piece of land out there is zoned to be used in a particular manner or be used for a particular purpose. And you have to use the land according to what it was zoned to be used for. Obviously, if it's, let's look at these. Here's some of the zoning classification. This is not all of them. But it could be zoned residential, commercial, industrial, agricultural, some special purpose. But those are some examples of the zoning classifications. Well, if you go buy this piece of property and it's zoned residential, then guess what you have to use it for or what you must do with it? it has to be used for residential purposes. Can I build an office on that property? No, you cannot. You can only use the land depending on what it was zoned to be used for. So again, that's something else you got to pay attention to when you're buying or selling land, but primarily when you're buying it. You might be buying land because you think this would be a good place to do whatever it is you want to do. But if that piece of land is not zoned for what you're wanting to do, then I suggest you not buy it, right? Unless there are some other options we're getting ready to talk about. We'll talk about those here in a minute. But the next term you see there is this ordinance. Sometimes you hear them called zoning ordinance. Ordinance really is another term for law. Zoning laws, zoning ordinances. But it says here, the primary intent of a zoning ordinance is to assure proposed land uses conform with the master plan. That's the intent, that's the purpose of zoning laws or zoning ordinances. It's so that we all conform with the master plan. Now, in my mind, I would think, well, who has the master plan? Who gets to decide what the master plan is going to be? I will tell you, in my mind, that would be Jesus. He's got the master plan. The problem with that is that's not going to be an option, or certainly not the right answer they're going to be looking for on the state exam if they ask you that question. But Jesus has got the right plan. I'd write that down if I were you. But anyway, the state has the master plan. Who else other than the state could know better how to use all land? I can't imagine. But they have. And then what the state will do, so they'll have this master plan for the entire state. And then they push down this police power, to enforce this plan at local levels, okay? In different municipalities will have what they call the Planning and Zoning Commission. And each Planning and Zoning Commission will enforce the master plan at their level, okay? And there'd be several throughout the state. All right. Then you see a term called a variance. Now, a variance, let me see if I can explain it this way. Let's say I buy a commercial property. Obviously, I want to put a business on. I want to start a business here, and I buy this property and it's zoned commercial. Now, something you need to know or understand about commercial. There's several different commercial zones. They have like C1, C2, C3. And yes, they're all commercial, but what they're doing here, the state actually governs what types of businesses are allowed in certain areas of town. So they will break out the commercial zoning into subcategories, if you will, or classifications. C1, C2, whatever. So now not only, if I'm wanting to put a business somewhere, not only does it have to be zoned commercial, but it has to be zoned in the commercial classification that would allow whatever type business I'm thinking about starting up to operate here. Well, let's say that this property I'm looking at, it is zoned commercial, but it's not classified for the type business I want to put there. Well, an option I might have, I can go to the local Planning and Zoning Commission and request a variance. Now, when you request a variance, in essence, what you're doing, you're asking the Planning and Zoning Commission to rezone that property from whatever it currently is to whatever it is you need it to be, to do what you want to do. Now, will they approve something like that? Well, maybe not. But it's something, I will tell you, it typically requires a fair amount of paperwork. You got to submit a lot of paperwork to the Planning and Zoning Commission. Basically, where you're trying, you got to spell out exactly what's your plan here. What do you intend to do? How are you going to do it? And all this stuff. Now, we'll tell you, when they receive it, and they're obviously reading through whatever you've provided, if all they see here is how much this will help you, you may very well not get it. They may not allow that. However, if you can show them or convince them that what you're proposing would be in the best interest of the public, now you might get their attention. In fact, chances are they will probably move to approve what you're asking for. But what they'll do, y'all assuming they don't, if they'll consider it, then they'll put like a sign on the property to basically give notice to the public that the owner of this property is seeking a variance. They want to do this, that, or the other thing with the property. And we're considering approving the variance. Now, if anybody's got a problem with this, then we're going to have a meeting on this day at this time at the Planning and Zoning office, and you need to be present to voice your concerns. And then the public can weigh in on whether they like the idea or don't like the idea. And then once that's all said and done, then the commission will either approve the variance or not. But that's what a variance is. Variance basically is a request to rezone that property. Okay. And then you see this term called non-conforming use. This is very common. Now, it's something you better pay attention to. And when you're working with especially buyers, you better be aware of this kind of stuff. Just one more thing. And this is very common where say, for example, you got some houses, residential homes. Is it possible that for some reason the Planning and Zoning Commission decides to rezone this whole area, maybe this strip, this street, this road, rezone it from residential to commercial? Because I don't know if you notice, a lot of times, the city, as it is growing, start spreading out. And actually, so you'll have the commercialized area start overtaking some residential areas. And when they do that, they'll just rezone that residential area to commercial. So now you got people living in their home that they've now rezoned to commercial. Well, if my house is now rezoned to commercial, do I now have to move out? Well, the answer is no. Because when I bought the property, it was zoned residential, and that's what I'm using it as. So in essence, you're going to be grandfathered. So as long as you live there, and as long as you own the property, then you can continue using it as a residential property. That's what we call non-conforming, because you're still using it in a way that currently does not conform to the zoning laws. You're not conforming because it's not commercial. So it's considered non-conforming, but that is legal. Again, as long as you own it and as long as you live there. Now, obviously, if you ever decide to sell the property or move out of the property, you can no longer use it in a non-conforming manner. Now, the new owner, for example, would have to comply with the new zoning requirements, meaning now they have to use it for commercial purposes. Okay, so that's the non-conforming use. And then the last thing we want to talk about right here is this thing called spot zoning. I don't know how this is a real big deal, but spot zoning is, you ever notice you can be in a very heavily commercialized area, a lot of businesses, restaurants, whatever, and then you'll see like a little cluster of residential homes. Yeah. So they might call that like a little spot zone where you got a little cluster of residential surrounded by all the commercial. Or it could be the other way around. You could have a little cluster of commercial property surrounded by a bunch of residential properties. They just call that spot zoning, and that's it.